in branding, you always want to put your best foot forward. I'm Mike Steger. I'm a trademark and copyright attorney, and today I'm going to talk about a trademark dispute involving one of Australia's iconic symbols. Not a kangaroo, not Outback Steakhouse, but boots that are called Uggs. In Australia, the term Ugg refers to unisex sheepskin footwear, primarily boots, and this term has been used for almost 100 years, both in Australia and New Zealand. An Australian company named Australia Leather sold 13 pairs of boots that were branded as Ugg as a description of the type of boot. They were sold into the US through their website, so 13 pairs. And as I said, in Australia and New Zealand, the term Ugg is used to just describe a type of footwear, sort of like you would say sneakers or even boots or sandals. An American company, Deckers Outdoor Corporation, owns the registered trademark for Ugg for various kinds of footwear, primarily sheepskin footwear. And it owns registrations that date back to the 1980s. With first use of this term in the US, allegedly in 1979. So Deckers sued Australia Leather for trademark infringement in Illinois. And they were found liable for trademark infringement. Last week, the Federal Appeals Court denied Australia Leather's appeal and basically said that you can't sell anything in the US with the word Ugg, even as a description, unless you're doing it under the Ugg trademark. This is a devastating decision for the Australian company and also just other Australian producers of footwear that use the term Ugg as a descriptive term. Deckers has trademark registrations in about 130 countries and essentially has worldwide rights to use that term other than in Australia and New Zealand. Australia Leather had argued that this term was descriptive and generic and should never have been registered in the US, but that argument was rejected. The lesson for this really is that your trademark rights go country by country, and just because you have the right to use something in one market doesn't mean you have the right to use it somewhere else. It's going to make it almost impossible for Australian and New Zealand footwear producers to export these goods and may really dry up any market for them. Australia Leather had vowed to appeal this to the Supreme Court, so there may be one more step in this footwear battle. If you have any questions about any trademark issues, I'm Mike Steger, trademark lawyer. Give me a call.